April 17th when we took the lunch break. Before we were talking about what we finished up with, you were talking about the way in relation to a question that I had of when did you look at the report after May 12th, you kind of went over what your procedures were for following the discovery in this matter. Do you remember that conversation?
How we did it in this case, yes, sir.
Yes. If you could, would you explain to the panel what your policy has been towards discovery during your career and how you looked at analyzing information that came in as to whether you should let it go out or not go out?
Yes,
to defense counsel, please.
Throughout my career as a prosecutor, I've always believed in open file discovery. I've always encouraged other people in my office to employ open file discovery. As far as I know, I've done that from the outset. When I first got to Durham Superior Court, it just seemed like a more efficient procedure. My feeling was that if I were worried about whether something should be turned over, then that would be an indication that it should be turned over. And if I weren't worried about whether it should be turned over, then that would be an indication it didn't matter if I turned it over or not. But that if I didn't worry about that and gave them everything, then I would never have to deal with issues about whether I had intentionally withheld evidence or whatever. My philosophy was always, if it's in my file, you get it. Now, police files or the case files that we had, of course, back in the 70s were not as voluminous as they are today, but I've always had the policy that evidence that's in my file is available to the defense counsel, and I've always given open file discovery. It's come back to bite me in some cases, but that's okay. I have often been the person in my office that people would come to if they were struggling over whether or not something should be given. And I like to think that that's because they figured if they came to me that they knew I would tell them to give it. And so they were trying to resolve it in that fashion. But I have always believed that was the policy. So for me, the 2004 version of 903 wasn't really a change in terms of philosophy. It was just, in essence, a legislation of what I'd always done, what I'd always encouraged other people to do.
Thank you. Before you ultimately indicted Mr. Evans on May 15th, is that correct? Or the grand jury did?
Yes, sir.
And before any of your officers went before the grand jury in any of these cases, either the indictments that were procured April 17th or those procured May 15th, did you have any conversations with the officers themselves about what they should present to the grand jury?
No, sir.
Did you ever ask them in any conversations during that period of time to sugarcoat anything?
No, sir.
Did you ever ask them to withhold providing any information that they had in their file from members of the grand jury?
No, sir.
Have you ever done that in your career?
I don't recall ever having talked to any officer about how he should testify before a grand jury or any other witness at any time in my career.
I believe that, after the indictments of Mr. Evans, there was a court hearing on May 18th. Is that correct?
Yes, sir. I believe that was the first appearance for Mr. Finnerty and Mr. Seligman. That was what happens is a lot of times our grand juries fall on our administrative weeks, and so we had a grand jury that met on the 15th, but that was also an administrative week when the calendarings of the Finnerty and Seligman cases occurred.
And explain to the panel here what it means in Durham County if a case is on its first setting as opposed to second setting and on down the road, or how a case gets calendared in the criminal system in Durham County.
As the panel is probably aware, a number of years ago there was a lawsuit in Durham County. It was originally against District Attorney Ronald Stevens. When he became a Superior Court judge, the new District Attorney Jim Harden got substituted. It was, I think the name of the lawsuit was Simeon v. Stevens, then Simeon v. Harden. And it was about the authority of DAs to calendar cases. And as a result of all that, we changed the system by which we calendared cases in Durham to a system that was developed really in consultation between the district attorney and the resident Superior Court judge with input from the local bar about how it should be done. It's actually signed by the judge and by the district attorney, but with local input. It's called our case management system, and it specifies for most felony cases 3 settings. The first setting is the setting by which or at which we determine if counsel is appointed, conditions of pretrial release, and we're supposed to comply with discovery at that setting. That is, our initial discovery compliance comes at that setting. A case may be continued on first setting, which is often the case if there is anticipated there'll be a lot of other discovery coming in later. It might be continued to second setting. Second setting is a setting at which the defense attorney has an opportunity to sit down with the judge and the DA to discuss possible resolution of cases. And then the third setting in the case is the time at which the case is either pled pursuant to a plea arrangement or arraigned on a plea of not guilty for subsequent calendaring on a trial calendar. So these are the 3 settings prior to being placed on a trial calendar that a case goes through. Where a case sits, actually, from many points of view, is the most important thing is whether or not the attorney's presence is, the defendant's presence is required. Defendant's presence is required at third setting. It's not required at second setting. It used to be required at first setting. I have eliminated that requirement myself for cases in which there's already appointed counsel. But at any rate, that's a lot of times the consideration for moving a case to a different setting depends on whether or not it meant the defendant wouldn't have to attend. But that was the system that we had in effect. Cases moved first setting, second setting, and third setting, depending on what was going on with the case.
Now, the hearing that was held on May 18, 2006, matters related to all 3 cases came on for some sort of hearing on that date. Is that correct? Or some action?
I'm not sure that the Evans case was actually set for hearing unless it was some sort of bond issue or something. He just happened to get indicted that week. And so what happened was, since we had to comply with discovery for everybody else, we went ahead and did a discovery packet, the same one for Mr. Evans as well. And we gave all those out on May the 18th. We hadn't actually received a request by that time for Mr. Evans, but we gave everybody everything that we'd received up to that point on May the 18th.
And I believe if you look at tab 216A,
yes, sir.
And you actually have 216A, B, and C. Those are just the same document for all 3 defendants. Is that correct?
Yes, sir. That's correct.
And on the back page of each one of those documents, there's a document that's a receipt for discovery for them. Is there not?
Yes, sir.
And each one of those indicates 1,278 pages of documents, 2 VHSs and 1 CDs were delivered that day, right?
That is correct.
And those were delivered, the information that was delivered that day was compiled in the manner that you previously testified to this morning. Is that right?
Yes, sir. I'm not sure that fully explained the procedure. I explained how we made sure that we had all the items that the officer had in our file. Then after that, at some point, a number of people in my office were involved in copying those files. There was obviously a lot of paper. I guess 3 copies of that ran almost 4,000 pages. And so we had to make copies of each document. And sometimes they were one-sided, sometimes two-sided, so you had to pay attention to what you were copying. And then assemble a package, an identical package for each defendant. We did 3 at the same time. I wasn't actually involved in that procedure. At that time, the office policy is that the administrative assistant does the discovery. Since it's all turned over, typically when I was the district attorney, I always did my own anyway. But in this situation, because of the amount of pages to be numbered and time constraints, other people assisted me in that. And so the first discovery response was actually prepared by people other than myself.
I'm going to come back with it. Going forward on, did you change the procedure for having office staff compile the discovery for you in this case at some point down the road? In other words, you start compiling it yourself?
Well, I started numbering the pages myself as they came in. Part of the problem the first time was all the pages came in at once. And so they had to be individually hand numbered. They weren't even all copied the same day. So other people did the numbering, and then people made the copies and made sure there was one of each number in each set. After that, as the discovery came in, I would put the discovery in a file which I would label, and I would put my own handwritten number on the discovery.
Okay. And then have it copied after you did the handwritten number on the discovery and provide it from there. Is that right?
Right.
On paragraph 5 of all of your motions, responses to voluntary discovery, it deals with the reports of the experts, and it also has Dr. Meehan's name below there. Is that right?
Yes, sir.
And at the time, explain to the panel what your thoughts were as to whether or not you had provided them with all the stuff that you needed to for Dr. Meehan as of May 18, 2006.
Well, by signing this report, by sending this, and then I certainly was indicating that I had, and I believed at the time that I had given them everything.
Right.
That was the subject of our discussion. I also assumed, and I think correctly in a case with the quality of attorneys that we had in this case, that they would be getting the underlying data at some point during the course of this proceeding.
Now, you actually appeared in open court on May 18th in front of Judge. Was that Judge Stevens on the 18th?
Judge Stevens was the first judge, yes, sir.
Okay. And there were conversations in that court hearing as to whether you provided everything to the defense that they were entitled to. Is that right?
Yes, sir.
And did you indicate to the judge that you had, in fact, provided all of the information that was in your possession, that you'd already provided that to the defendants?
Yes, sir, I did.
The information related to the non-lacrosse player male DNA on the rape kit items was not ultimately in the report.
It was not.
Okay. And you had previously indicated that they should have had it, right?
Absolutely.
Okay. So the statement that you had provided them everything that you had wasn't correct, was it?
Not actually. I provided them every document that I had received, but since that was not in a document and since I had not made notes of that conversation, then I had not provided them that information at that time.
Did you believe your response in Exhibits 216A, B, and C to be correct at the time that you executed that document?
Absolutely I did, yes, sir.
When did you learn that the representation in that document was, in fact, not correct?
I think that I realized it on December the 13th when I got the motion for additional discovery or something that it was entitled from the defense attorneys. I had actually been expecting them to file 2 other motions that week and had been told that those motions would be filed on consecutive days. I had not been told I was going to be receiving this one. And so I got the motion and I read over it, and my first reaction was a variation of oh crap, in terms of I looked at that and said, I didn't give them this, and then I went back and looked at the report from DNA Securities, and I read over it, and the information clearly was not in there in a direct form.
I'll come back to what steps you took at the December 13th from there. But going forward, what, if any, involvement do you remember having with discovery or matters related to the case between May 15th and June 22nd of 2006?
Specifically between the 15th and 22nd?
Yeah, if you have any specific recollection of that.
Well, I mean, we would be proceeding in the same manner that I had indicated previously, that as the papers would come in, I would organize them in that fashion so that I could make sure that all the pages were numbered and we knew where we stopped for the numbering of the last discovery. We were going forward from there. I don't recall anything specifically in terms of unusual about that, but then at some point prior to the June 22nd hearing, I assembled that additional material that we had collected and made 3 copies, one for each defendant, for presentation in court.
Okay. And ultimately, other motions came on to be heard at the July 22nd, 2006 court hearing in this matter, right?
Yes, sir. What normally would happen is we would make a discovery motion in this case, and then we would get some sort of supplemental from one or more of the attorneys asking for specific information they believed existed that we hadn't provided. And a lot of times we would use that as an opportunity to go check with the police department to determine whether that information existed. Sometimes we could get it right away, or we could determine that it did not exist and make that report. But we did use the additional or the supplemental request from the defense to tailor our search for documents that they believed existed that we had not provided yet.
And in the June 22nd, by the time we got around to the June 22nd hearing, there were various motions that counsel for each of the defendants has filed where they were requesting either follow-ups or additional amounts of discovery. Is that right?
Yes, sir. My belief is that at that point I was still getting motions from individual defendants, that they had not at that point joined everything into a single motion. But I was getting motions, yes, sir.
And when you get a motion in either for supplemental discovery or just regular discovery, what steps would you take to make certain that you determined whether either you'd already complied with their request, or what steps did you take to get more information to comply with their request, or determine whether that information even existed?
Well, depending on the quantity of information that was requested, and if it were just one or two simple things, I might pick up the phone and call the investigator myself and say, do you have Officer Jones' report or whatever? They're asking for that. We need to get that. As we got later on into this and things came up and there were larger requests, then many of those tasks in terms of determining exactly what existed and where it was fell upon my investigatorial assistant, Linwood Wilson, who I would task with basically give him certain pages of the report that said, we're asking for this and this and this. And I said, I need for you to either get this or talk with the officer and have the officer tell you that it doesn't exist and report that that's what the officer said. So it really depended on what the nature of the evidence was and how easy it would be to check whether it existed.
And there were, the way, when you got into court, did the court usually deal with each one of the defense attorney's motions, and did you go down basically a list of what they had requested and said this is what we have or this is what not there for each one of the defendants?
Sorry, I didn't mean to interrupt. Yes, sir. We would, if there were pending motions for discovery matters in each of those hearings, we would go over that and say, with respect to this item, this is the information I have for the court. With respect to this item, this is the information I have for the court, and answer in that fashion.
And issues came up at the June 22nd hearing about whether or not the defendants had all the information from your meetings with Dr. Meehan. Is that correct?
Yes, sir, I believe that's correct.
And in that portion of the hearing, did you represent to the court that they had everything that you had because they had the report and you didn't talk about anything other than the facts of the case?
I don't recall my precise response, and I'm sure it's in the deposition. But in terms of having reports, I did indicate that I had given them everything that I received from Dr. Meehan, which I believe to be a complete recital of his results in that case. At some point, I may have indicated that some of my discussions, I don't remember if it was this hearing or another hearing, that my discussions with Dr. Meehan were in terms of how we were going to use the material at trial. That is, we discussed issues about how we would describe the evidence and some of the things that we would go into in that sense, some of the things I talked with the court about earlier with respect to that. I don't know if that was specific to this hearing or not.
And prior to making, in any of the subsequent discovery hearings, either June 22nd, September 22nd, did you go back prior to making any representations in court and review all of the discovery that you had previously provided to the defendants to make certain that you hadn't missed something?
You mean, did I go back and look at like, for instance, within the first 1,278 pages?
Yeah, like, for instance, would you go back and review the May 12, 2006 report of Dr. Meehan to make certain that it did, in fact, contain everything that it needed to contain?
Not for that purpose. I mean, obviously there'd be times when, for other purposes, non-discovery purposes, I might need to go back and look at a particular document or somebody's statement or something like that, but not as part of discovery response when I go back and look at previous materials.
Okay. And at the June 22nd hearing, there was an order that was entered as a result of that hearing. Was there not, dealing with providing all of the underlying data of the Dr. Meehan and DNA Securities?
I believe that's correct, sir.
If you go to tab 221.
Yes, sir.
If you could, did the judge order that the underlying data from DNA Securities be provided to the defendants at the hearing on June 22nd?
I'm sorry, are you asking if he asked me to produce that material at that hearing?
Not at the hearing. We were required to provide it at some time.
I believe that he did say in item 2, having to do with expert witnesses, that I would furnish the defendant's underlying basis for that opinion at a reasonable time prior to trial as specified by the court.
Right. And did you understand that you were required to produce any of the underlying data as a result of that order?
Well, I knew all along that I would be producing the underlying data. If you mean, did I understand that I had a specific date by which to produce it?
Yes.
No, sir, I did not.
Okay. And I think the first paragraph of that order would have had you provide some other documents that doesn't comply. And I apologize for this, but I didn't put that back in my notebook yesterday, so I don't have the order in front of me. Paragraph 1 would have you provide statements of different witnesses. Is that right?
Yes, sir. And
there's no time restraint on that in the order, is there?
No, sir.
And did you ever, why didn't you provide a memorialization of your meeting with Dr. Meehan pursuant to the terms of that order?
Well, the first reason was that I believe that our discussions, I mean, of course, at this point you understand that the mention of the non-matching DNA was not even on my mind. But in terms of the contents of the meeting in general, the first thing that I would say is that I believe that my discussions with Dr. Meehan, other than when he was telling us the results of the test of the rape kit and things of that nature, were about how his testimony was going to be used, and so would not have to be presented because they dealt with that aspect of the state's case. At the same time, just generally in terms of my conversations with witnesses, it was my understanding that the Attorney General's office was arguing in the case of the State versus Shannon that the term statement in the discovery law did not mean that we had to write down, as prosecutors, had to write down every conversation that we had with a witness. And so I hadn't done that. I hadn't, I guess the meeting, Bill Hart, who was the Assistant Attorney General, had appeared at the DA's conference in the fall after I was appointed. So it had been the fall right before this took place. I guess the October 2005 DA's fall conference, and had provided us with a copy of the state's brief in State v. Shannon and what their argument was going to be. So I had not made any attempt to memorialize all the statements that were made to me, because that wasn't my usual practice to take extensive notes, and because my belief was that the Attorney General's office was suggesting we take the position we weren't required to do that under the statute.
And that case was on appeal during the State v. Shannon case was on appeal, and actually a decision was entered in that case somewhere the first part of this year. Is that right?
I don't know exactly. It might have been, actually I believe it was maybe in January now, because I know that we talked about it pretty early on. Yes, sir, there was a decision rendered by the Court of Appeals that differed with the Attorney General's interpretation of that statute, and there was a 2-to-1 split, but my recollection is that it had to be remanded for further proceedings in Cumberland County before they could make a determination as to whether their ruling applied specifically.
Wait just a minute. Let me ask a question here.
Yes, sir.
So was it your understanding that the Attorney General was taking a position in that case that facts related to a prosecutor by an expert were protected by work product and therefore not subject to the statutory requirement that those discussions be memorialized?
No, sir. If I gave that impression, I gave the wrong impression. It was my impression that discussions of work product were not something that I needed to provide. I mean, that was something. But it was also my impression from talking with the Attorney General, well, not the Attorney General directly, but with Mr. Hart from the Attorney General's office, that they were taking the position and arguing to the court that a district attorney or assistant district attorney who interviewed a witness prior to trial did not have to memorialize and provide a written copy of that statement. I was still responsible, obviously, for giving information that was information that was given to me somehow. And I've said all along, I'm not suggesting that the information on the DNA was not information I shouldn't have given. I should have given that. I'm just saying that because I was not taking notes and because I didn't make a point of writing it down, I didn't have it in a position where I could find it later and say, oh my goodness, I didn't give this.
So the requirement to take, your understanding was that what was at issue was the requirement to take notes with any witness that you might be talking to, whether that entailed matters that might be otherwise subject to work product protection, or whether or not it included any discussion of facts that might be exculpatory in nature for which you would have an independent duty to disclose?
I'm not sure that I understood your question. I certainly agree that we had an independent duty to disclose anything exculpatory in nature regardless of how it's discovered.
Right, so you're not relying upon that position of the Attorney General to excuse any failure to disclose facts that were exculpatory in nature that were conveyed to you by Dr. Meehan?
Absolutely not. And whether or not they were exculpatory in nature, if they were facts related to his investigation, I believe that I was supposed to relay those. Whether you look at them as exculpatory or non-exculpatory.
That's my next question. Whether they're exculpatory or not, what in your discussion with an expert, even a testimonial expert, relating to his findings would you consider to be subject to work product protection in any of it?
When a district attorney specifies in a statement exactly what he went over with a witness and what subject matter was covered with respect to, in this case, an expert witness, then giving a statement with respect to exactly what was discussed would indicate the manner in which the state intended to present that witness at trial. In other words, when I talk to a witness, I'm probably not going to go over every single thing in a witness's statement that was ever said, because I'm not going to be interested in everything that was said. I'm going to be concentrating on individual parts of that statement that I think I either need to explain or deal with. And so if I only ask about certain things, then a report of that conversation, of the statement that was made in reference to that, would indicate what I was concerned about or what I intended to use out of that statement at trial.
Let me ask you this. Do you consider any of the discussions that you had with Dr. Meehan, whether it's 2 or 3 at that time, were they covered in whole or in part by the work product doctrine?
I consider some of the discussions to be, yes, sir.
Now, at that time, now, none of that involved, did it, any preparation for his trial testimony, because indeed no trial had even been scheduled.
That's certainly true. But any time that I talk with an expert witness, it will be with an eye toward how I'm going to use him at trial. But I don't want to I mean, obviously I'll be glad to answer any of the court's questions with respect to this, but I'm not suggesting that I did not have an obligation to turn over that material. I'm not trying to say that this is an exception that would excuse me from that. That is not my point at all. If anything, it just has to do with the reason that I don't take notes in these situations.
Okay. Were you specifically aware at that time of the statute that on its face requires you to take such notes?
You're talking about 15A-903?
Yes, sir.
Yes, sir. And that, again, that's where my understanding of the Attorney General's position, State v. Shannon, was that the prosecutor did not have the responsibility to take those notes. I understand that is now the minority opinion from the Court of Appeals. But it is...
Well, if it's the minority opinion from the Court of Appeals, it's not the law.
No, sir. As a matter of fact, it's not the law, but the statute specifically said that it would not define the terms, but it would allow court decisions to do so. And no court decision had existed at the time that I made this decision. I'm not suggesting that, clearly in hindsight, it wasn't the correct decision.
Did you was it your practice at the time specifically not to take notes in order for it not to be discoverable.
No, sir.
Why didn't you take notes?
I generally didn't take notes because, well, and I did turn over to the disciplinary hearing committee, or the grievance committee, I guess, a very few notes that I took in this case, because they were about, and they have some of these notes. I rarely took notes because usually I only took notes if there was something that I needed to remind myself of or to remember. And most of the time, I mean, there are very few notes, for instance, with my contact with the SBI. And a lot of what they entail is the YSTR testing labs that might do some testing and some telephone numbers, because I would need that to contact them. But I didn't take extensive notes about the actual content of the conversation because I assumed that that would be in the reports that were presented when I talked to expert witnesses.
All right. I apologize, Mr. Witt. You go ahead.
Thank you. Moving forward to the September 22nd, 2006 discovery hearing that you had. Who was it that presided over that hearing?
September 22nd, I believe that was the first hearing that we had under Judge Smith.
Okay. And was one of the issues that was addressed at that hearing the obtaining information from the SBI of their underlying data of the DNA testing that they had performed?
Yes, sir.
And was another one of the issues that was addressed at that hearing obtaining the underlying data for the tests that were performed by DNA Securities?
Yes, sir.
All right. And before that hearing, what did you do to get prepared for that hearing to know what position to take when it came up before the court?
Well, there was a joint omnibus motion filed sometime in August. The date may have been August the 31st. I'm not certain. And I believe that was the first joint motion that had been filed by the defendants in this case. But it set forth a number of items of discovery that they were seeking. And two of the longer ones were the underlying data from the SBI and from DNA Security. Many of the items that they were requesting were items that I could pretty easily assign to Glenwood Wilson because they were officers' reports and things of that nature. And I said, I could just say, go check with this officer and get the report or find out why there isn't one. With respect to the two fairly complicated inquiries, what I did instead was to fax a copy of the specific request involving the SBI lab to the SBI lab, and the specific request involving DNA Security to DNA Security, and then follow that up with a phone call. At the SBI, I spoke, I believe, with Mr. Budzinski, and I went through item by item things that were requested and said, do you have this? Is this the kind of thing that you normally provide? Do you have any objections to providing it? How long will it take? And things like that. The responses were different in the two places. The SBI lab had some restrictions on a few things that they did for personnel reasons, but indicated the same results might be available in another category. I think in terms of proficiency tests, they said that would deal with one of the things that we're talking about. But at any rate, they made specific objections and gave me the reasons for the objections that they had to those things, and I made notes in the margin of my copy of the motion for that. And then when I spoke with Mr. Meehan at DNA Security, he did not object to providing any of the information that they requested. In other words, he didn't have specific personnel policy objections to anything. But he did indicate that there would be a cost, which I asked him to estimate because we would be paying for that. And he also renewed his concerns about releasing the complete DNA profiles of the 46 players. I guess it would be a single page or maybe two-page profile for each player. I just asked him to put that into a letter to the court that I would present to the court to state his position on this, and he did so.
And did you present those matters, did you bring those matters to the attention of Judge Smith at the September 22nd hearing?
I did.
At that hearing, did you object to an order being entered requiring you to produce any of the underlying data, either from the SBI or DNA Securities?
I did not object. I did make a statement, and I believe the court may have already heard it in the earlier testimony. It was what I would call a snide remark, or maybe I might even use another smart aleck or something like that expression. One of the things that had happened immediately after the April 10th SBI report had been turned over was that there had been a press conference and an announcement with respect to the fact that all the DNA didn't match any of the players. They were all totally exonerated, and we'd had something similar come up after May 12. And so I made the comment to the court, and it was probably, certainly in retrospect, not an advisable comment, but I was being, since I was not commenting outside of court on anything that was going on, this was my way of commenting about the fact that these lawyers are complaining that are saying on the one hand that the DNA doesn't match anybody and exonerates everybody, but on the other hand, they're looking for ways of attacking it. And so I made that comment, but it was by way of, the comment that I made was something like, and it said these are the standard witch hunt witch hunt motions that are made. Said it's interesting that on the one hand that they say that the DNA results exonerate everybody, but on the other hand they're seeking information to help attack those results.
Where was that comment made?
That comment was made in open court, and it's in the transcript, and I believe was testified to previously in this hearing by a witness.
September 22nd?
In the September 22nd hearing.
All right.
But other than having made that ill-advised remark, commenting on that issue of the way the defense was presented, I did not make any objection.
Did you hear Dr. Meehan's testimony the other day where he said that you faxed him a copy of the report and you asked him you faxed him a copy of the discovery request and you asked him whether or not that was, a standard request, or was that more than is usually requested?
I heard his testimony.
Did you ever have any conversation with Dr. Meehan such as that you recall?
I recall having a conversation with him after I faxed the motion or whatever over. And it was kind of along those lines. It was in the sense that, is this the kind of stuff that you're willing to provide voluntarily? Do we need a court order? The exclusions. I'd already talked with the SBI when I spoke with Dr. Meehan, and I knew that they had objections to a very few of those categories. I didn't know if Dr. Meehan would have those same specific objections or not. He did not.
And after the hearing, after finishing the hearing, did the court order that the state provide the underlying data from both those laboratories by October 20th, 2006?
Yes, sir.
And then yesterday there was testimony, I believe, about a conversation that occurred on October 19th, 2006 in relation to the need for finishing up an order related to the September 22nd hearing?
Was this a conversation between...
Conversation between you and Mr. Bannon. Because the order didn't get executed until after October 20th, did it?
Yes, sir. At some point it came to my attention, and I'm not sure if it was by telephone call from Mr. Budzinski or what, that the SBI, although they had the data assembled and were willing to give it, could not, under their policies, give it without a court order. And so I don't know. I was thinking that our office had contacted Mr. Bannon. He said it was Mr. Budzinski that contacted him. But at any rate, there was a conversation involving a court order, and he did fax over a proposed copy of a court order for me.
And if you look at Exhibit 226 in the documents in front of you,
yes, sir.
Is Is that a facsimile to you from Mr. Bannon?
Yes, sir.
And does it have attached to that facsimile a copy of a proposed order?
Yes, sir.
And in paragraph 4 of that proposed order, on the page 2 of the order, do you see where there's the wording, the third line up, that says the word final report of DNA securities?
Yes, sir.
All right. In Exhibit 226A is a letter that I believe you prepared and sent back to Mr. Bannon related to the proposed order. Is that right?
Yes, sir.
And in that letter, you make no objection to the wording final report in paragraph 4 of the proposed order, do you?
No, sir, I didn't object to that. I don't know that I noticed that I was specifically interested in some other things, and I may have overlooked it, but I did not make any objection to it.
Did you believe that the May 12, 2006 order was a final order, an interim order, or what was your understanding as to the status of that order?
Well,
report, excuse me.
I'm not objective. You're talking about an order.
I corrected by the report. The May 12th report. Did you? The May 12th report. And in my question, let me go back and clear this out.
Try that again.
Yeah, I'll try that in a minute. Page 2 of the proposed order, paragraph 4, talks about a final report of DNA securities,
yes,
right?
It does.
All right. So now my question to you is, what was your understanding of the status of the report that was provided to you on May 12, 2006 by DNA Securities as to whether it was final or interim report, excuse me?
I don't recall ever even having thought about it. I mean, I asked for the order because I needed it to comply with 15A-282, and after that, I don't know that I really thought much about the whole question of final order or interim order or anything.
At the time you received the May 12, 2006 report, did you know whether there was going to be any more testing of evidence items by DNA Security?
It was my understanding that there were still a few items that they had not received, including, I believe, the buccal swabs from Mr. Baumler and Mr. Saley, perhaps some other information. And so I knew that there may be some additional testing going on if those items were received. But whether I thought about that in terms of, a final report or a separate report, I'm not sure that I ever thought in those terms at all.
From May 12, 2006 up until December 13, 2006, what steps did you take to make certain you received the report of any additional tests that DNA Security did after May 12, 2006?
I didn't take any steps.
Why not?
I guess because it never occurred to me that I needed to.
All right. Had DNA Securities provided you with the underlying data that they were required to provide you by October 20th, 2006?
I believe that I did have that by October 20th. I did not yet have the SPI, but I believe I did have theirs.
Okay. And on what date do you believe that you transmitted the information received from DNA Securities to the defense counsels?
That would have been on the 27th, actually. I think that we eventually got it all on the same day and got it done that day.
Okay. And what was your understanding as why the SBI materials hadn't been provided by the 20th?
Because they had not received an actual order by that time.
What did you do as far as going back and reviewing the data that was provided by DNA Securities to make certain that it contained everything that it needed to contain?
I did nothing. I mean, we had a couple of very large notebooks and maybe some other stuff. I didn't make any attempt to. I wouldn't know what to look for.
Okay. Who did you rely upon to make certain that DNA Securities complied with the court order of September 22nd?
I relied on DNA Securities. I guess Dr. Behan.
After you provided the documents on October 27, 2006, when's the next matter that you remember having any discovery issues come up related to this case?
After October 27th?
Yes, sir.
I guess it would be the December the 13th motion.
Okay. And I believe you already testified to what your thoughts were when the motion came in. What did you do as far as preparing to get ready? Well, strike that question. Did the defense request that the matters raised in the December 13, 2006 motion be handled at a hearing that was scheduled for December 15th?
Well, the motion requested several alternate forms of relief. They requested to be handled at that hearing. Yes, sir. That was my understanding. They wanted to handle it that day.
Okay. At the time you appeared at, I'm going to back up a second and come forward. At the time you appeared at the June 22nd, 2006 hearing, what setting was this matter on in your case management system? Was it still first setting or second setting?
June 22nd?
Yes, sir. Do you recall?
It would have been first or second setting, but I don't recall specifically. It may have been moved to second setting, or it may have stayed on first. Neither would have been unusual.
Okay. And had any trial date been set up at that point?
No, sir.
Had there been any motions, such as a motion to express or any sort of motion that required an evidentiary hearing that had a time set as of June 22nd, 2006?
Yes, sir. I believe that it might have been Mr. Osborne who had filed initially a motion to suppress photographs or a photographic display, the one that was viewed earlier today. And my understanding from the attorneys was that there might be either additional motions or a more comprehensive motion filed in that case. And then my further understanding was that that motion would be filed the week of December, I guess it's the week of December the 11th, the week that contained the dates December 13th, 14th, and 15th. And I believe that I got a total of 3 motions that week on 3 consecutive days. The December the 13th motion was the one that we have discussed, and then there was one for a change of venue and one for a suppression of photographic evidence.
And was that at the June 22nd hearing? That motion wasn't scheduled for December 15th.
No, sir. No, sir.
Okay. And at the September 22nd motion hearing, was the case on any trial calendar at that point?
No, sir. The case never made it to a trial calendar, or never, for that matter, never made it to our third setting, which is the setting at which it's determined whether or not a trial will occur.
And at the September 22nd, 2006 hearing, were the motions that you thought may be heard the week that contained December 15th, was that already scheduled for that date?
I'm not sure if I understood your question.
The motion to suppress, as of September 22nd, 2006, was it scheduled for hearing at any time?
The motion to suppress?
Yes, sir.
No, sir, it was not.
Okay.
With respect to the September 22nd hearing and our case management system, my belief was that the appointment by the Supreme Court of Judge Smith to preside over the remaining portions of the hearing was part of a designation of this case as a special case that took it out from under the purview of our case management system anyway.
All right, moving back up to December 13, 2006, you got the motion in. What steps did you take to try to provide any information that was requested by the defense?
Well, as I indicated, my first reaction was they don't have this, and I didn't provide this. And then my second reaction was, at least they got it. I felt a little relieved. I just couldn't believe that I hadn't given it to them, so I went back and looked at the report. And then I said, well, at least they have it at this point. And then I looked at the motion. Pardon?
They had what at that point?
Well, the motion indicated that when they looked over the underlying data, they had found the evidence of the non-matching DNA, and that was what the motion was directed toward. But although the motion was entitled a motion for additional discovery or something, what they were attempting to discover appeared to be, from what they were asking for, evidence of an agreement between myself and Dr. Meehan to conceal this evidence. They wanted things like phone logs or recording, or I guess notes of conversations or things like that. So
Your inference of what they were asking.
that was, yes, sir. Well, things like, since I believe the motion said,
I might have you turn to Exhibit 229.
Let him finish it.
I'm just going to say that the motion was phrased in things like, since anybody who deals with this kind of case would know that this is exculpatory information, and since we didn't get it, then something must be going on. I mean, that was what the thrust of the motion seemed to be to me.
That was your inference from what they were asking for in the motion.
And the way the motion read, yes, sir.
That was your inference as to the intent of the motion, correct?
Yes, sir. I believe that Mr. Bannon said that the only reason they didn't phrase it that way particularly was because they didn't have any specific evidence yet.
Bannon told you that?
No, he said that. I believe he testified to that.
Oh, okay. I'm not. All right.
So, but at any rate, not at the time, no, sir. So, the first thing I did was to fax a copy of the motion to Dr. Meehan. I didn't even speak to him that day. I just faxed him a copy of the motion, said this was just filed, please read it, and I'll call you in the morning, or something along those lines. And, the next morning, I called him and I said, this is something that we need to deal with right away. The allegation that we've tried to hide evidence is something that we need to dispel in this case. So I need for you to come in and testify if you can. Can you come in and testify on the 15th? He said, I don't know. This is short notice. I'm not sure I'll be able to do it. I don't think that I can. And so got off the phone with Dr. Meehan that morning, believing that we would not be able to hear the matter the next day. He called me back later in the day and indicated that he had rearranged his schedule and that he would be able to be here, being in Durham, on the morning of the 15th.
Was that conversation on the 14th?
Yes, sir. That was
the day after you got the motion?
Yes, sir. I got the motion on the afternoon, or read the motion on the afternoon, and realized what was going on. I faxed him a copy of the motion that day. I don't believe that I spoke with Dr. Meehan until the next day, which would have been the 14th, the Thursday.
Okay.
And on that day, he told me that he did not, initially told me he didn't believe he could be there the next day. But then he subsequently called me back and said that he'd rearranged his schedule and he could be there. And so he came in, I guess the motion was to be heard at 9:30. He came in around 9 and asked if he could see the documents that DNA Security had provided in discovery. And of course, we still have them in the same format in our box. And so I said, sure, here they are.
The 1,844 pages? Or the report?
Yeah, well, I'm not sure that if all 1,844 pages were theirs or not. But whatever he gave me, it might have been 1,844 pages or some other quantity of pages in notebooks, were in our evidence file. And so he took those portions of the evidence file, which were marked and numbered in order, as were everything else, and took them into our conference room and reviewed them for a while. And then he came back and said, do you know if you furnished these documents? And showed me some additional papers that he said were not in the notebook. And I said, well, I don't know. If they're not in the notebook, maybe not. And so we made copies and furnished them that morning, but it turned out that they had already been furnished. They were in a separate file from the notebooks, but consecutively numbered. So we actually gave those twice. We had given them prior to this morning, but out of an abundance of caution, when he said he wasn't sure if we'd given them, we went and made other copies.
And that was at the district attorney's office?
On the morning of the 15th.
And then you went over to court with him?
Yes, sir.
From your office?
Well, I'm not sure if I went, because first we were in the chambers about the medical records and so on. So I'm not sure if Dr. Meehan went directly to the courtroom with me or not, because I know I went to chambers to discuss with the other lawyers and Judge Smith the medical records and things like that first.
Okay, you continue, Mr. Good.
Did you have any conversations with Dr. Meehan on the 14th about the substance of any questions that you might ask him if he were tendered as a witness on the 15th?
No, sir. I knew that there had been no agreement. I knew that there was nothing like that. It was my intention just to put Dr. Meehan, call him to the stand and tender him for their questions, because one of the things that they had asked for was the opportunity to question him under oath. And so I was just going to tender him to the court for that, and that's what I did.
Did you hear, did you ever say, I'm sorry I didn't provide it to the defendants either in chambers or at the court hearing or in the beginning of the court hearing?
No, sir, I didn't, because they already had it at that point. I mean, I was sorry that I hadn't done it, because nobody wants to deal with that kind of allegation. But they had discovered that they hadn't gotten it on their own and had made this motion based on their having discovered it. So at that point, there wasn't really anything for me to give them, because they had it. But it was, obviously not something that I had ever dreamed of having to deal with.
As it relates to any of the statements that you made to the courts at any of the hearings, either the May 18th, June 22nd, September 22nd, or at any other time where you indicated that they had all of the underlying information, including any exculpatory information, that wasn't true until they received the material October 27, 2006, related to the male DNA that were non-Duke lacrosse players. Is that right?
You're correct. I believe the statements were true at the time that I made them, but on December the 13th, I realized that they had not gotten that report until October, or that information until October the 27th.
And you didn't take any steps between May 2nd and December 5th, May 12th and December 15th to go back and look at that report again prior to making those representations to the court, right?
At any time prior to December before December 15th, and I did look at December the 13th.
Okay, but from the time of May 12th, 2006 up to December 13th, 2006, didn't go back and look at the report to make certain that you're
not for that
wrong.
purpose. If I looked at it, it was for some other purpose, but I did not read or find that was missing. Okay. It was something that I really just didn't think about again until I got this motion on December 13th, and then it was just kind of like,
All right. Now, let's move back and just change off subject. Do you remember having any meetings with Crystal Mangum from the time you became involved in the case up until December of 2006?
Until December?
Yes, sir.
I believe in that period of time I probably had 3 meetings with her.
Okay. And in that period of time, in those meetings, did you have other individuals, such as the investigative officers, that might have been with you in those meetings?
There was always somebody else present when I met with her, yes, sir.
Okay. And did you ever discuss the facts of the case or any of Ms. Mangum's inconsistencies in any of those meetings?
Never discussed them in any of those meetings.
Why not?
Well, the first meeting that I had with her was on April the 11th. And I'm not sure of all the people who were present, but that was in my office. She came in with Investigator Hyman, Sergeant Gottlieb, I believe Lieutenant Mike Berger, who was another officer, and there may have been some additional officers in addition to that. And she came in, and that's when I met her for the first time. I was introduced to her. She seemed to be, at that point, I mean, the word I would use was somewhat traumatized still. She had, it's kind of hard to explain what I mean, but she had a way of, when she sat in a chair, she kind of shrunk, so she looked smaller than she really was. And when I tried to talk with her, and what I was doing was introducing myself and letting her know who I was, and letting her know about the process that we were going to be dealing with in terms of the case, as we brought people what we were doing in terms of investigation. And, you know, if we do indictments, we'll do them this way, and let her know that after indictments, these things happen and stuff like that. It became obvious to me as I was talking with her, and she would kind of, you know, be like this, and she'd look up, but not quite raise her head all the way, and kind of look, and she just did not seem to be ready to talk about the facts of the case. That wasn't why I brought her over there on that day anyway, but it struck me that it would have been a total waste of my time to try to talk with her about the case at that time. I've seen similar things in other sexual assault victims, but it's by no means universal. I've seen other sexual assault victims that react totally differently. I've seen some that were a lot worse than she was. But my impression was that that something really bad had happened to her and that she wasn't ready to deal with it yet. So all we talked about at that point was the introduction and how things moved through the DA's office and how we did stuff like that. And we didn't really talk about anything that would involve her having to do anything at that point.
Do you remember any of the other meetings you had with Ms. Mangum between the date you got involved in the case and the beginning of December 2006?
The next meeting was probably a few months later. I don't remember the exact time. I think that Officer Clayton may have... and when I say we, my administrative assistant, Candy Clark, who was also going to serve as my victim witness legal assistant in this case because we worked in that fashion before. We sat down, and at that point, we were wanting to make sure that she was doing okay. We'd found an alternate living arrangement from her outside of Durham. Initially, after this happened, she was being followed by media people, and every time she tried to go somewhere, and was having difficulty getting around in Durham without some kind of inconvenience, and thought that this was not a good thing. And so the DA's office wasn't involved with it. I think that perhaps one of the women's support groups was involved in getting her into a place in another county with her children. And she'd expressed some concerns on that day that she didn't really have any transportation, that she wasn't able to either find a job or to look for a job or to get back and forth to a job, and that she really wanted to move, wanted to come back to Durham because it just wasn't a convenient arrangement for her. But that was pretty much all we talked about on that day. We did not talk about the facts of the case.
When was it that you understood would be the first time that she may need to testify?
Well, the first time that we knew that she would need to testify would be at any suppression hearing that involved the photographs that you saw earlier. We weren't sure as it turned out, all these initial hearings, every time that we'd have one and furnish all the discovery that we'd received up until that point, there'd be significant additional discovery requests from the defendants about other items that they felt that they should have had or wanted to know if they existed, and we would go look for those. And so the discovery process was turning out to be pretty lengthy in this case. I think we all knew that it would be lengthy, but it may have been a little more lengthy than we had anticipated. And so we were trying to get through the discovery process as much as we could, I mean, with the understanding that there are always going to be things that are subject to being turned over up through trial. We wanted to get through as much of that as we could before we set anything for hearing. We'd also been informed that there was going to be a replacement motion to suppress, so that although there was a motion to suppress filed, that would probably not be the motion to suppress if they wanted heard. So that motion wasn't set until, I believe, the December the 15th hearing, when it was set for February the 7th, is my recollection. So we knew that we would need to be calling her as a witness for a hearing on February the 7th, when we left the hearing on December the 15th.
What steps did you take to attempt to get Ms. Mangum ready for the hearing that was set in January?
The hearing that was set in January?
February, excuse me.
One of the problems that we were dealing with at the time of the December the 15th hearing is that Ms. Mangum was pregnant and was having a very high-risk pregnancy. She had actually, before she delivered a child, I think was admitted to the hospital on 3 different occasions and then released. So during this period of time, we were dealing with these issues, and we weren't sure. At one time, they were thinking they might have to induce labor or to take the child by a C-section or something. We didn't know what we'd be working with there, and it was kind of hard to schedule anything at that time. But I had asked Linwood Wilson, in preparation for trial, to interview Ms. Mangum, and it's been stated throughout this case that she told many different versions of what went on, and certainly there were.
Did you say preparation for trial?
Just say, well, it's for the hearing, but also for the trial. I mean, that if we, obviously anything that we do is for all the proceedings down the road. Nobody had ever talked with her to find from our office to find out what her version of the facts was directly to us. We had never dealt with that. One thing to the district attorney's office. What I mean is this: what happens often in sexual assault cases is that obviously when you're dealing with somebody who's just been the victim of sexual assault, then they're most likely not going to be in the best state for making coherent, factually consistent statements. And so it is not at all uncommon for there to be variations between the initial statement that somebody makes and subsequent statements. And they don't usually have to do with somebody changing the story so much as they have to do with the person to whom the story is being told not understanding what was being said or not successfully writing down what was being conveyed, so that your initial baseline story may not be exactly what was told by the victim to the officer. This is particularly a problem in a case if the officer doesn't realize he's dealing with this kind of situation to begin with.
Did you have reason to suspect that the previous version she had given had been inaccurately transcribed?
Yes, sir, for several reasons. An example would be there was a version from one of the Duke officers who overheard a Durham officer talking on a radio and said something about heard the officer having said that she was raped by 20 men at a party. Now, my suspicion is that what was actually said was something like she was raped at a party where there were 20 men. But when you have people overhearing things and reporting on what they overheard, it's not at all hard to get away from what was actually said. And so much of what passes for, in many of these cases, for inconsistent statements or inconsistent recordings of what's being said or misunderstandings of what's being said. And then, of course, after that has been mistranscribed, anytime you ask somebody about that after that, you said that 20 men assaulted you. Oh, no, I never said that. Well, that may be true. But then now you've got, she's saying something different now. So you always have something along those lines to be dealing with. So one thing that I asked Mr. Wilson to do was to sit down with her and, have basically the statements that she had been alleged to have made, and to talk with her about those and to see what her statement was at this time regarding what had occurred.
Why did you send Mr. Wilson rather than have a conversation with Detective Hyman or Sergeant Gottlieb about that?
Well, Mr. Wilson is as the prosecutorial investigator, assists us in getting cases ready to put on for whatever stages of trial or pretrial proceedings there are. He's not an investigator in the sense that he goes out to try to solve a crime. Normally the way that we use investigatorial assistant is to get information from other witnesses, like we did with the police reports, often to find witnesses that we might need for trial or proceeding. We use them to do background checks on people that we know will be testifying either for us or that we've learned maybe witnesses for other people. And then we can also use them to interview witnesses in this situation. So that's what we were doing at that time.
What directions did you give Mr. Wilson as far as what his scope of his interview with the victim should have been at that point in time?
As far as I knew, all he was going to do was to talk to her about all these supposed statements that had been made in the past and what her response was to all that in terms of her story having changed and all.
Well, wait a minute. He was told to discuss with her specifically her different prior statements.
To confront her, in essence, with the fact that, did you ever say this? No, I didn't.
And then was he also asked to say, well, what are you saying now?
Yes, basically. We were trying to get a version after we'd gone through. See, all these initial statements were made pretty early in the investigation. And whether they were made to officers at the scene or to investigators later on, they were made within a few days of the situation. And we wanted to find out what her memory of these events was at this point.
Did you tell him to take any photographs with him when he went to interview her?
The only photographs that I knew that he was taking were photographs that I believe had been broadcast on one of the television networks that were supposedly photographs of her at the party. It might have been in MSNBC. I don't know. We had essentially paper copies of video files. They weren't particularly good. But to get her information about approximately where during the course of the event this photograph might have been taken.
Did you learn that he took other photographs at some point in time?
Not at that time.
When did you learn that?
I think that when I learned that there were other photographs involved was when I got a telephone call or maybe a letter from Mr. Cooney. And Mr. Cooney asked, what we did after we got the statement from Ms. Mango, we sent, as part of discovery, both his written statement and the notes that he had taken in making that statement.
Wait a minute. Written statement. What written statement?
Mr. Wilson obtained a written account. He did a written account of his interview with Ms. Mangum.
His statement of what she said.
Yes. In other words, his memorialization of her oral statements to him.
What about a transcript or a recording of what she said?
He did not do. He also produced his notes. He did not produce a recording.
Why not?
Well, I didn't ask him specifically to do that, and I guess he assumed not to, because I didn't ask him to. Although, as you'll see, that might. I don't know the reason. I can't tell you the reason that he didn't do that. I did not ask him specifically.
You did not. Did you give him any direction as to how to memorialize that interview in any way? In other words, did you tell him, well, take good notes or whatever? I mean, what did you say to him about that?
I told him to memorialize the conversation the way he would with any other witness, to take notes of what she said and to produce for me a written report of what she told him.
Was that at the DA's office? Was it at your office?
I don't believe so. I'm not sure where he interviewed her, but I don't believe it was in our office. I think because of her physical condition, he had to go where she was at that time.
Let me ask you this. I understand Mr. Wilson is an investigator for your office. Does he go out and take other witness interviews from time to time as part of his ordinary duties?
When you say witness interviews...
witness interviews, victim interviews.
He has done that on occasions in the past.
What is his general modus operandi as to whether those interviews are recorded?
Let me just... I can answer the question in this way. We're not using him in that fashion anymore.
When did you stop?
I don't recall the exact date, but there...
Was it in 2007?
It was either 2007 or late in 2006.
Very late 2000. Correct?
It might have actually been in 2007, but...
Did he do any after Ms. Mangum's interview?
Not for me. I'm not sure. There was another question that came up involving an interview that was done for someone else, and I'm not certain when that was.
Prior to this interview, had he done other interviews specifically for you in your case?
No, sir. Mr. Wilson was at one time a police investigator. He had also served for a number of years as a private investigator and worked primarily, I guess, in domestic cases. Actually worked with many of the lawyers that were involved in some fashion or another in this particular case. But he had retired from private investigation, and I had hired him as an investigator in my office towards the end of 2005.
Did he have a PI license?
He did at one time. I don't know if he still has one. I don't know how that works, so I can't really answer your question.
Are you aware of any witness or victim interviews that he did that he recorded at any time?
I'm not sure what you mean. You mean tape recorded?
Tape recording, digital recording?
Not specifically. I can't tell you that he never did that. I don't recall.
Any AV equipment whatsoever, other than taking notes? Are you aware that he did that on any occasion?
I'm not specifically aware, but he did very few interviews for us, actually. That wasn't his primary function.
Okay, well, why'd you ask him to do it? If that wasn't his primary function. You must have realized this is a pretty critical interview. Because the intent, I take it, was to find out what she was saying before she has to go testify at this suppression hearing, correct?
Well, actually, it was the first step in doing that. I was going to have to interview her myself prior to the suppression hearing to speak with her, and I would have done that with somebody else, but I wanted a kind of a starting point for that interview.
Why wouldn't you do it yourself to start with, since you were the one that would have to present that evidence in court?
I chose not to do that at this time, at that time, and that was probably a mistake. It was probably a mistake not to have interviewed her earlier than I did in the first place.
Had you personally, I know you personally had met with her prior to that, but I take it you had not, up to Investigator Wilson's interview, spoken to her substantively about the events at the lacrosse house.
That is correct. Yes, sir, that's correct.
True. Now, the police investigators had, correct?
They had early on in the investigation, yes, sir.
Why couldn't you rely on that as sort of your baseline as what she was going to testify?
I could have done that. I chose not to do that. And I certainly, very probably made a mistake in doing that.
Was an attempt made to ascertain from her, either by Mr. Wilson or at any other time, what she may have learned about what the defendants may have been saying about what happened that night?
I don't know that I specifically understand your question.
Did anybody ask her, well, have you read or heard anything about what the defendants are saying happened?
I don't know that anybody asked her that question, but there actually was another part to this whole situation that might be, this all arose out of a question about what photographs were shown, because I think that my attorney was going to ask you something that you may or may not be aware of, but might inform some of your further questions.
Well, yeah, I'm sorry to take over questioning. Go ahead, Mr. Pitt.
Did you end up letting the defendants know, the defense counsel know, what photos Mr. Wilson actually took to that interview?
At the request of Mr. Cooney, as I recall, I did ask Mr. Wilson what photographs were used, thinking that he had used a few photographs from this MSNBC report that were supposedly pictures that were taken during the party while Ms. Mangum was there. And in the course of that, I learned that he had also shown her the photographs in the ones that you saw today, the ones in the lineup.
Say that again. Showed her what?
He had shown her the 46 photographs that you saw in the video presentation today. He had paper copies of those photographs in his file. And the way he explained it to me was that when he opened the file to take out the pictures he was going to show her, those pictures were in the same file, and she showed them. And on his own, even though they were the subject of a suppression hearing, and even though had I thought that there was any possibility that he would have even taken those photographs with him to this interview, I'd have said, don't think about it. He showed her the photographs that were the subject of the suppression hearing.
Would you call that a lineup, a photo lineup at that point?
I don't know what he called it. But what we found out, and this may go to the questions you asked earlier, what he discovered was that she was now referring to the people not as Adam or Brett or Matt, which, by the way, our feeling all along was that those were most likely not only made-up names, but that they probably used those names interchangeably to be more confusing.
Made up by whom?
By the people who were assaulting her. That was the way we're looking at it. In other words, that if you were going to be assaulting somebody in this circumstance, you probably wouldn't call each other by name. And if you used made-up names, you probably wouldn't even necessarily stick to the same one, because the whole idea is to be as confusing as possible about subsequent identification. But at any rate, We learned at this time that she was now referring to the three defendants, not by as the guy who was in front of me or the guy who was behind me or whatever, but by name, which indicated that she had at least seen some coverage of this case. I mean, obviously the defendant's photographs had been displayed on more than one occasion in various media accounts, and so it appeared that she now was referring to these people by name.
Well, yes, anybody who had seen a newspaper after the indictments would have known that, right?
Yes, sir.
So what did that do to your evaluation as to your chances of getting by a suppression hearing?
I thought that did not help my chances of getting by a suppression hearing in the least. I mean, obviously that's devastating to a suppression hearing.
And
I furnished that information to the defense attorneys immediately.
And without her ID, you had nothing, did you?
That's correct. The case against two of the defendants was based entirely on her identification.
And that was on the 21st? That was the Wilson interview?
The interview was on the 21st. I did not discover that those photographs had been shown until whenever, at some point after that, after I had given the additional reports of that interview to the defense attorneys, then I received Mr. Cooney's letter wanting to know what photographs were shown and got that information. I don't have the specific date, but I mean, whatever date that I gave that, I would have written a letter back to Mr. Cooney.
Did you know about the photos that were shown prior to dismissing the rape charges?
Excuse me?
You dismissed the rape charges after the Wilson interview, correct?
Yes, sir. Yes, sir. Mr. Wilson called me after that interview. It was late in the afternoon, and he indicated to me that he had spoken with Ms. Mangum. Didn't tell me too much about the interview at that time, other than to say that in talking with her, that she was no longer able to say with certainty that one of the items that was, or one of the objects that was forced upon her was a penis. She could not say that a penis was ever inserted into her vagina. And that, of course, is what constitutes the act of rape. And since we had no independent evidence of that act, then we had no evidence that would support that particular offense.
Well, that was a very significant difference, wasn't it, from what you had said before?
Yes, sir, it was a significant difference.
And you knew that if you went to trial on that charge, she would be subject to cross-examination about all of her earlier statements in which she said that, yes, I had been penetrated with a penis, didn't you?
It's my belief that she would have been subject to cross-examination about that in the trial of any of these charges.
Well, up until then, she at least was consistent in saying that she had been violated by a penis, correct?
I'm not sure that she had been asked that since the initial stages. I mean, in other words, it wasn't like
she had been asked that to bring a rape charge, correct?
What I'm saying is, I don't know that she had been asked about that other than at that time. So when you say that she was consistent all along, I mean, all these statements were made in a very short period of time.
Well, and I know I'm jumping ahead, but why did you dismiss the rape charges and not the sexual assault charges?
Because for a sexual assault, you don't have to know what object is inserted. Any object that's inserted, for instance, into the anus would be a sexual assault. Any object other than the penis that's inserted into the vagina would be a sexual assault.
I know the law about that, but tell me, so at that point, is it fair to say that based upon her statement, you felt that her testimony would be sufficient to proceed to trial on the sexual assault cases, and that was your intention to do so, correct?
I would say my answer to that question would be this. I think that a sexual assault case or a rape case is the only kind of case, probably, that the only witness that you have to have is a prosecuting witness who can say this event took place. And that if you have a credible prosecuting witness to say that took place, that is enough to get a conviction beyond a reasonable doubt. And if you do not have a credible prosecuting witness with respect to that, then no other amount of evidence is going to get you that far.
What was your assessment of Ms. Mangum's credibility at the time you dismissed the rape charges?
I had no direct assessment of her credibility with respect to anything at that point. I mean, I don't know how to answer your. I didn't think that necessarily meant that the charges couldn't have occurred, but obviously, as was the case with many of these things, the case, the further along that we got, was developing additional problems. And, it seemed to me that the case would likely stand or fall on the basis of what happened at the suppression hearing.
Wasn't it important that you personally interviewed her by the time you decided what charges you were going to go to trial with?
In retrospect, I would say that would have been a good idea. I'm not sure that it would have resolved the issues specifically in this case. What I would say is this. At the time that we made that decision, all of the people who had spoken with Ms. Mangum were convinced that she was telling the truth, except for Officer Shelton. He was the only one that expressed any concern about that.
What about Investigator Hyman?
Investigator Hyman never expressed any questions to me, and I believe his testimony was that when this first happened, he did believe her, that it was only after he saw an interview that took place at the Attorney General's office after they took over the case that he believed that it might not have happened. In addition to the officers not raising any questions about this, the same nurse also had findings that were consistent with an assault having taken place. There have been other occasions in the past where I have interviewed victims with respect to the charges specifically because there was somebody who had a significant question about some portion of the story. There were no questions presented to me by anyone in this case about her story. And when I say her story, about the allegation that she was sexually assaulted.
Now, just to be clear, because I got a little bit off track there, it was after you dismissed the rape charges that you found out later that your investigator Wilson had shown the photographs of the players to her?
Yes, sir. I don't recall the exact time, but and there again, I'm sure there is paperwork that would support that. But with respect to the actual dismissal of the rape charges, that was entered the next day, because at that point we had no credible evidence either from her or from any independent source that there was a penis involved in the assault, which would be necessary.
You had no DNA, no sperm DNA.
That's what I'm saying. So that would be the kind of independent evidence that would, if she weren't sure, might show that a penis was involved. But without any sperm and without her ability to say that she was assaulted with a penis, we had no evidence that would support that conviction. So I dismissed. And
no physical evidence, no third-party corroboration. You had her word for it, correct?
No, I didn't have her word for it at that point.
You didn't?
Not after she said that she could no longer be, that she was not certain that she was penetrated by a penis.
All right, I guess the flip side of that was she's not certain she was penetrated by a penis. Did you have her word that at that point she was penetrated by something, and if so, what was it?
Well, not all of the penetration in this case was vaginal penetration. There were also allegations of anal penetration, and any object that is used anally would be a sex offense. as any object other than a penis that was used vaginally would be a sex offense.
I understand that, but my question is, what was the object she was saying was penetrated in? Was used to penetrate her in any of those orifices at that time?
I don't think she knew.
Let me ask a more fundamental question. Was she unequivocally stating that she was penetrated with something in some orifice at that time?
At which time?
When Linwood Wilson interviewed her. Right?
I don't believe that she changed that. I believe so, yes, sir.
Okay. So the extent that what you knew at that time was she was alleging at the time of the Wilson interview that she was penetrated with something somewhere.
Yes, sir.
Any more detail than that?
Well, I'm sure there was. I don't recall it at the time.
Do you recall it now?
No, sir, I don't recall it. That's what I'm saying. I don't recall all the specific details of that statement at this time.
When you found out about the photographs that had been shown to Ms. Mangum, what was your assessment of your chances at the suppression hearing? Say percentage-wise.
Well, I don't know that I ever evaluated it in that fashion, because about this same time I got a notice from the State Bar somewhere in this same general period of time that an ethics violation complaint was being made against me. And so it became fairly obvious that I had a conflict in this case. That is, that it would be hard for me to both prosecute the case and be a defendant in this proceeding. And so my focus at that point was, after we got her through the childbearing complications, that I needed to talk with her about whether she wanted to proceed in light of all this, because if she did, I was going to need to ask another agency, specifically the Attorney General's office, and to proceed with the case. And I had some preliminary discussions with Mr. Coleman about the fact that I had reached this conclusion and I needed to speak with her, and that I was not sure when I would be able to talk with her because of her health situation, but that it would be my intention to speak with her about the case to make sure that she wanted to go forward with it before I made any attempt to send it over, but that I wanted him to know that was a consideration. Then when I did speak with her about the case, and it was January the 12th, is that...
Well, we're jumping ahead, and I think I hijacked Mr. Witt's direct examination, but again, you got the bar complaint, the initial complaint was served or filed on December 28th. Does that sound right to you? It may have been. It could have been. I know that
it was late in December. I don't know specifically.
Oh, wait a minute. I'm sorry. I got a cataract. I can't read this. It was filed on the 20th.
20th of December.
Is that correct? Okay, you got it on the 20th. And the Wilson interview was the next day?
The Wilson interview was something I'd asked him to do prior to this time, and the problem, as I indicated, was that the complicating factor was her state of health, and so I was not sure when that interview was going to be accomplished.
Well, did the scheduling of the interview have anything to do with your receiving the communication from the bar?
Absolutely not. I did not even know that when the interview was scheduled at the time. The interview, I had spoken to him about conducting such an interview before I got this complaint, and was not even thinking about the interview.
Right. I think we're all confused. I'm looking at that board. My recollection is that you got the letter of notice regarding the second complaint. That is the DNA matter on the 20th, but the actual lawsuit, the complaint of the lawsuit was filed the 28th. Am I stating that correctly?
Yes, sir.
Okay. So,
I could refer you to Exhibit 233.
okay, but what I said is correct, that you got the letter of notice from the bar on the 20th regarding what had transpired in the hearing on the 15th. Then you got, on the 28th, the complaint, the DAC complaint, the initial one, that included only the charges relating to the pretrial statements. Does that sound right?
That sounds right, yes, sir.
Okay, I apologize for that.
That sounds right.
But what you're saying is none of that had anything to do with, one, the decision to interview Ms. Mangum, or two, who would do it, or three, how it would be conducted.
That's correct, yes, ma'am. Yes, sir, I'm sorry.
What?
I accidentally said yes, ma'am. I'm sorry. I didn't. I'm sorry.
That's all right. Slip to the tongue now. Okay, Mr. Witt.
Do you want to turn to Exhibit 231, Mr. Nifong?
Yes, sir.
Is that the letter of notice? The second letter of notice, does it have a date on it?
It seems to be, yes, sir.
What's the date that's on that letter of notice?
The letter of notice is dated December the 19th.
Okay, and then after that date, you were served with a copy of the original complaint in this matter. Is that right? Do you recall that? After you received that letter of notice?
Oh, the original, yes, sir.
And was that after the date you received that letter of notice?
Yes, sir.
And did you have a conversation with when was your first conversation with Mr. Coleman about him taking over the responsibilities for this underlying case?
I believe it was in January, the first part of January, but I don't know the exact date.
Okay, just first part. It was in 2007, not 2006, right?
Yes, sir.
Okay. And did you sit down with Ms. Mangum before the time that you formally requested the AG's office to take over the investigation and prosecution of this case?
Yes, sir, I did.
And when was that meeting with Ms. Mangum in relation to the date that the AG's office took over the case, to the best of your recollection?
It would have been right before that, because what I did was I met with her and spoke with her, and then after I did that, I sent the formal request to Mr. Coleman, and they accepted on the following day.
And when you met with her before you transferred the case over to Mr. Coleman, what was the purpose of that meeting with Ms. Mangum?
Well, I wanted to explain to her why I felt that I could no longer be involved in her case, that my presence in the case would hurt the case and would not allow her side to be presented in a manner that was fair to her. And I told her that the people that would be taking over the case would be the Attorney General's office. If we chose to send it, we would ask them to take it, and I had gotten assurances that if we did that they would accept it. And that I wanted to know before I did that if I did so, that she would give them her full cooperation, and because I didn't want them to take the case and to spend their efforts on the case if she were not wanting to follow through with the charges. And I also explained to her what I perceived to be some of the difficulties that the case would have for her in terms of not only in terms of evidentiary issues that would be difficult to overcome, but also in terms of just the emotional trauma of going through a trial. And I tried to explain this to her in as fair a way as possible. I didn't want to make her decision for her, but I wanted it to be an informed decision. And after I did so, she indicated that She wanted to proceed with the case, and she requested that I transfer the case to the Attorney General.
Did you, you didn't ever meet with any of the defense attorneys and talk to them about maybe talking to any of the their underlying clients in the criminal case, did you? Anywhere going along?
No, I did not.
Okay, and why is that?
The only person that I recall specifically saying that he wanted me to discuss the case with him and his client was Mr. Cheshire, and that was at a point before Mr. Evans had been indicted. Mr. Osborne wanted to show me some photographs of something after the indictment, which ended up putting in his motion to suppress, but I don't recall Mr. Osborne ever offering to sit down with me and his client.
Did you ever think about calling up and asking them about sitting down and talking with their clients?
I did not.
And why not?
I don't recall ever having discussed a case with an attorney in terms of a pre-indictment situation, that if I had evidence to present to a grand jury that I felt would satisfy my word in front of the grand jury, then I would present that and let the grand jury make its decision. I don't recall and it could have happened at some point. I just don't recall that I ever have sat down with an attorney to let him tell me all the reasons I should not indict his client.
Did you observe Mr. Seligman testify here today?
I did.
Seemed like a fine young man, didn't he?
He was a very impressive young man.
And if you would have had an opportunity to sit down and talk to him before any charges were filed or after sometime when those charges were filed, would you have taken that into consideration in deciding whether or not to continue to pursue those criminal charges against him?
I believe that if I had done so, and that Mr. Seligman had presented himself the way that he did today, at the very least, I would have sat down with Ms. Mangum and talked with her about the situation and reevaluated the case under those circumstances. Yes, sir, I think I probably would have done that.
Do you, sitting here today, have anything else you may want to say to the members of the panel, people in the audience, or people viewing this proceeding?
I was told by my attorney that he was going to ask me this question. And I didn't tell him what I was going to say. Throughout my time, it's going to be difficult, actually. Throughout the years that I have served as a prosecutor in North Carolina, I have always tried to do the right thing. In this case, I was trying to do the right thing. Much of the criticism that has been directed against me in this case is justified. The allegations, however, that I'm a liar are not justified. I felt that it was important to come before this commission and to defend myself against allegations that I intentionally misrepresented anything to any court at any time, because I have never done that, and I would never do. I have always been somebody who believed in giving everything to the defense attorneys before trial, because you don't want an unjust result. I have always, as my parents raised me, tried to do the right thing, and have always been willing to take responsibility for the things that I have done, right or wrong. I take responsibility for the things that I have done in this case that in any way contributed to any injustice being done. But I do not take responsibility for a lie that I didn't tell. Any misrepresentations that I made about anything in this case were unintentional. And it is important for me to say that. As you may know, I've been here this week with my wife and my son and other family members and friends and supporters. When I saw Mr. Seligman on the stand today, I thought that his parents must be very proud of him. I'm very proud of my son. I want him to be proud of me. And I felt that it was important for him to see this, because I've always told him that in this case, although I made mistakes, I was trying to do the right thing. And that I was going to come in here and I was going to defend my good name. And that's why I'm here. But it has become increasingly apparent during the course of this week, in some ways that it might not have been before, that my presence as the district attorney in Durham is not furthering the cause of justice. It is not fair for the people in my community to be represented by someone who is not held in high esteem by either the members of the community or the members of the profession. It does not contribute to the cause of justice in Durham for me to serve as a sitting district attorney if every time I walk into the courtroom, people are going to be pointing a finger at me and saying, there's that guy with the Duke Lacrosse case. I will go to my grave being associated with this case. And that's okay. I don't have a problem with that. I took the responsibility on myself, and I don't intend to pass it off on anybody else. You know, whatever mistakes I made in this case are my mistakes. They're not all the ones that the bar says I made, but they are my mistakes. For the last 14 months, unintentionally, my family and the families of David Evans, and Reed Seligman, and Colin Finnerty have been kind of joined at the hip. Everything that affects one of us affects the other. I think that's going to be the case as long as I'm the district attorney in Durham. I think that I can't do justice, I can't do the right thing if I allow that to continue. So it is my intention, whether or not, whatever the decision is to make, to resign as district attorney in Durham. I came here as district attorney to defend my name. But it would not be fair to my community to put them through a recall kind of motion. Why do that to them? My community has suffered enough. They suffered as a result, in some respects, of my actions in this case, although honorably intended, not having the consequences that I desired that they would have. So, to the extent that my actions have caused pain to the Finnerdys and the Sillians and the Evans, I apologize. To the extent that my actions have brought disrespect or disrepute to the bar, to my community, I apologize. But I cannot admit that I told a lie that I didn't tell. And I still intend to defend myself against those allegations.
Let's take